what kind of time limit have you got me on? Ballpark, this shouldn't take more than 5 minutes, but.
Have at it.
All right. For those that aren't familiar with Dillon's rule, it basically just says you only have the power authorized. And with that in mind, the powers are limited to those listed in the statute. When you look at the 911 statute, specifically 15.4, it outlines exactly what you have the authority to do. One of those powers says you can hire staff, but it's silent on entering into a multi-year contract for their employment. Had the legislator, or even in this case the county board who established the ordinance, wanted employment contracts as a designated power, they would have stated as such, just as they have done in other statutes, such as the school code, water district statutes, etc. My point is, the board was never given the power to award an employment contract to personnel. With that contract in mind, and this is using State's Attorney Devine's own words, which we have on video, a contract that was never placed on the agenda for a vote is an invalid contract. That language came from the dissolution of ICOM, an entity that was never legally formed because it was never on the agenda for a proper vote. The contract you have with your 911 director is much the same. It was never legally entered into, nor could it be without statutory power to do so. And I'll leave copies with you, but we've had these for a couple of years. The actual agenda, there was no action item to enter into a contract on the agenda. We FOIA'd that specifically. And I'll just pass this agenda forward here. That's from the FOIA that we requested for the agenda when the contract was approved. It's not an agenda item. And then the minutes, there's no vote to ever approve this contract in the minutes. There's a copy of the minutes from 2014. It specifically outlines that a motion was made, but there's no agenda item to support a vote, and there were no votes recorded in that. In addition, the law says no expenditures may be made from such funds except upon the direction of the board by resolution passed by a majority of all members of the board. Can anyone on the board provide me with a copy, not necessarily right now, but could provide a copy of a resolution passed by a majority of all members to spend money on an employment contract? That's never happened, and that's a statutory requirement for expenditure of funds out of 911. Even if she had a legal contract, it terminates March 25th, 2017. That is clear. Remembering Dillon's rule, I would ask that you show the public where in the law it gives you the power to send an invoice to emergency service agencies for dispatching emergency calls, because you will not find that in the statute. The county is authorized to impose a fee to every phone line in this county for the purpose of 911 dispatch for emergency service. There is no provision in the law for the very agency created with their money to turn around and charge their local emergency service provider for the very service they just paid for, i.e. dispatching. More importantly, the illegal invoicing is recoverable from a False Claim Act, which we would encourage happen in this case because it is not a legal path. All monies received, this is right out of the statute, all monies received by a board pursuant to a surcharge imposed under Section 15.3 or dispersed to it under Section 30 shall be deposited into a separate interest-bearing emergency telephone system fund. That tells you where your money comes from and what you can do with it, and where you're supposed to put it. So my question is back to Dillon's rule. What legal instruction governs money received outside of Section 15.3, which is the phone fees? You see, you're receiving money that was obtained without legal authority and now are depositing it without statutory instruction and then dispersing those funds, I suspect, without proper resolutions. The law is clear. It tells you how funds are received and where they are to be deposited. Your director, as I understand the events over the years, is using fear and intimidation in order to subsidize her budget. When Grandma in rural county, Iroquois County, calls 911, this agency has a duty by law to dispatch an appropriate emergency agency and is not given the power to charge those agencies for that dispatch. For this agency, either directly or through its director, to imply those agencies would not get dispatched unless they pay a dispatch fee is nothing short of a form of blackmail or extortion. I challenge this public body to present statutory authority to bill emergency agencies to dispatch in an emergency. That's my watchdog hat. As a fire chief, in today's technology, right now on my phone, there's an app called Who's Responding. I can get a page for my ambulance and my fire department right now, sitting right here. And it doesn't cost a penny other than an annual fee that we pay for the app. And there is no statutory authority to charge for dispatching. And for emergency agencies out there that are paying that, I would love to see where the statute gives you the power to do that, because you're not going to find it. And I understand some other agencies are doing it. We're talking to them just as well. We put a stop to it in our county a long time ago. And unless there's statutory authority, it can't happen. That's all we're asking for. That's all I've got. Thank you.
Thank you. Any other public comment?
No, but Chairman, I think before we go any further, we need to go into executive session to discuss that.